Hello everybody, Martin Radner here from Radner Law Group, bringing you trial analysis. Today we're going to be discussing the YNW Melly trial and some more updates about what's going on, some more analysis that everybody needs to hear and to understand exactly what's going on. And every time that you turn around in this case, there's another issue, another motion being filed. There's been dozens and dozens of motions that were filed by the defense, motion to suppress evidence, and motions in limine, and responses by the state. There's just been motions flying everywhere in this case. And we've got a recent filing by the state. The state filed a motion, and we're going to discuss that shortly. Before we do, there's another issue which we spoke about in previous videos, which actually came to its head recently also, and that was one of the requests by the defense in this case was to be able to take Detective Moretti's deposition again. And as you recall, we discussed this in a previous video that generally speaking, you're only allowed to take one deposition of a person, of a potential witness in the discovery phase. But in this case, there was more information that they found out about Detective Moretti, and that was because of this other prosecutor, Michelle Buttress, who came forward and said that she witnessed Detective Moretti soliciting a deputy to lie for him in order to get the search warrant, in order for the search warrant to be valid. And because of that testimony, that's what caused this whole motion for dismissal, because of the Brady violation that occurred. And we've spoken about all this in previous videos. You can go and check it out to get the full analysis. But at the end of the day, the judge did order that Detective Moretti's deposition could be taken again a second time. There was good cause to be able to take his deposition again, and that deposition is going to occur, but it's going to be limited to these new findings or these new questions about soliciting this deputy to lie for him. So you can't just open up the whole case again and spend 7 hours with him. You're only allowed to discuss this specific instance where he was allegedly soliciting a deputy to lie for him in order to have that search warrant be valid. Okay, so that's the update in terms of Detective Moretti. But now we have something very interesting. So now, what's been going on with jury selection? So we know that there's going to be two phases of the jury selection. The first phase is just to see whether jurors can commit the time that it's going to take to sit through this entire trial. So they have to be able to sit through the entire jury selection process, and they also have to be able to sit through the entire trial, which is going to take a long time. So the first step, really, before getting into all of the more in-depth questions that the attorneys are going to ask, is first to just qualify the potential jurors that they can actually sit for this extent of time. So that was the first period, and then after that, there's going to be other further questions by the attorneys, perhaps by the judge also, about their different biases and prejudices and things like that. So the state files this memorandum of law, and apparently what happened was the following. What happened was that there was 2 weeks of what the state refers to as time qualifying jurors. So there's 2 weeks of where they spent time qualifying jurors to see if they can actually just sit for the extended time. And then the attorney's questioning began on November 6th, 2023. So that's when we're getting a little glimpse into the courtroom, which we're not able to see because the cameras are all off now. But this is what the prosecutors, the state is telling everybody that, well, he's telling the judge, but we can see it, that the attorney questioning began on November 6, 2023. Okay, so that's when the attorney, the judge, finally, we got enough of a panel that agree that they're going to be able to sit for the extent of the time, and now we can actually turn it over to the attorneys and let them start asking their questions of the jury or the potential jurors, right? So this started November 6, 2023. The state, and I'm taking this right from their memorandum, the state spoke to the first group of prospective jurors in part on Monday, November 6, 2023, and finished its portion of voir dire on Tuesday, November 7th, 2023. So Monday and Tuesday, that's when the state got up, the prosecution got up. They were asking different questions of these potential jurors. Defense counsel began their voir dire on group number 1, okay, different groups of juries, on group number 1 on Tuesday, November 7th, 2023. So the prosecution, the state, they had Monday and Tuesday, and then they turned it over to the defense, and the defense got up and they started their voir dire on November 7th, 2023. Now, listen to what happened. It's just unbelievable. It never ends. The excitement never ends with the Melly trial. By the way, if you haven't yet, please subscribe to the channel, like the video so we can continue growing and bringing this unparalleled analysis to the people that are looking for it. So this is what they say. During defense counsel's voir dire, counsel improperly informed the jurors that the state must prove all the elements of the crime, including the defendant's gang association, beyond a reasonable doubt in order for the defendant to be found guilty. So that's what the defense got up. The defense got up and said, and asked the jury, do you understand? There's something like this. I don't know the exact words, but something along these lines. Does everybody understand that in order to convict my client, Melly, that the state must prove all the elements of the crime beyond a reasonable doubt, including the gang association? That is a misstatement of law. And therefore the state objected, because they got up and they right away said, Your Honor, that's not the correct law. So you can't be asking the jury that they have to find that Melly was associated with a gang in order to find that he's guilty. In order to find that he's guilty, right? The gang association is a second aggravating factor that they could consider also, but it's not necessary to be able to convict Melly of first-degree murder if he's not associated with the gang. If he's not associated with the gang, he can also be convicted of first-degree murder. It doesn't have to be that he was associated with the gang. But the defense, they misspoke, and they said, do you understand? They asked the jury, do you understand that the only way that you can convict Melly is that all the elements of the crime, including the gang association, is proven beyond a reasonable doubt? And that's why the state got up and objected. And then what happened was that the court, the judge meaning, requested a sidebar. So the prosecution got up and objected, and then the judge said, let's have a sidebar about this. And during that initial sidebar, counsel was told to rephrase the question. So the defense counsel, they told the defense counsel, rephrase the question. Now, listen to this. The defense counsel subsequently read the indictment to the jurors, which includes the gang enhancement language that was included in the indictment, and again indicated to the prospective jurors that the state has the burden to prove all of these elements, including the gang enhancement, beyond a reasonable doubt in order to be found guilty. So again, he makes the same mistake again. Now, we don't know which attorney this was, but after the sidebar, and he's told by the judge to rephrase his question, he gets up again, reads the indictment, which includes the gang enhancement part, which is part of the indictment, and then again he misstates the law, saying that they have to prove beyond a reasonable doubt that Melly has this gang association in order to find him guilty at all. And in fact, the state again objected, and in addition, a juror asked himself or herself asked the defense counsel to clarify. And this is what they said, asking, are you telling me that if we find the defendant killed the victims, but not that it was part of the gang, that he's not guilty? Meaning the juror picked up on this and said, hold on a minute, you're telling me that if we don't find that he's part of the gang, that means that we should vote that he's not guilty? So then they had another sidebar, where again, so now they have a second sidebar. And again, this is what the state requested, is that the state requested that the court, meaning the judge, should read the jury instruction to the jurors, which would clear up any confusion, meaning the defense already misstated the law twice. So the state is saying, listen, judge, just you read the law, from the jury instruction exactly what the law is, and that will clear up any misconfusion that the jurors have. Now, what happened is that the defense counsel objected to the court reading the instruction. The defense counsel said, no, we can't do that. You can't just read the instruction. Why? Because they had further argument, and part of the reason that the defense didn't want that to happen is because that it's going to ruin he's going to lose, this is exactly the quote from the memo, that the defense counsel moved to strike the entire panel as he would lost all credibility with the jurors should the court read that instruction. Meaning the defense is saying, wait a second, you can't read this instruction now because I already told I told this whole panel what the law is, and now the judge is going to correct me. I'm going to lose all credibility with this panel. They're all going to think that I don't know what I'm doing and that I don't know what I'm talking about. And then that's how they're going to view me the entire trial, that I don't really know what I'm doing. And that's going to hurt Melly, because they're going to think that this lawyer doesn't really know what he's doing. He doesn't really know the law. So therefore, the defense counsel said that wherefore we have to strike the entire panel. This entire panel, that I made the mistake of misstating the law twice, not once but twice, I want you to remove the entire panel now and just completely start again. And guess if the state wanted that? Well, of course the state didn't want that. The state wants the jury to think that these guys don't know what they're doing. So the state objected. However, the court granted the defendant's motion to strike the panel. So now the court said, you know what, just for the abundance of caution here, we don't want to have another mistrial. We don't want to make additional issues for appeal. So let's just remove the whole panel. And that's what the court did. The judge completely removed the entire panel. So now, what's this memorandum of law now? So what does the state want to do now? Well, the state is telling the court, let's not do this again. Let's not go on this roller coaster again. The state fears that every time the state objects and said objection is sustained, the defense will move to start over because it affects their credibility with the jurors. So the state's saying, look, they might mess up again. Maybe they're going to make another misstatement of the law. Maybe once, maybe twice, maybe 3 times. And then what's going to happen? Then we're going to make the objection. We're going to have a sidebar. The court's going to have to correct it either by reading the jury instruction. And they bring some cases that really all the judge has to do is read the jury instructions. So in order to correct any misconception by the jury. So the state is arguing that we can't have this going on. We can't have this continually going on where the defense is going to misstate the law and then we're going to strike out the entire panel because they're going to lose credibility with the jury. So that we can't do. And that is the crux of this motion. Now, I just want to point out that it's a good point the state's making. The state's making a reasonable point here, that we can't, just because you as an attorney keep making mistakes and are losing credibility with the jury, well, that's Melly's fault for hiring you guys. You guys are better to know the law better. And you know what? And the judge will correct the jury and then correct what the law is. So the state does have a decent point here. But I do want to say, there's just to clarify exactly what's going on with the aggravating factor, with the gang enhancement here. So the state is correct that you don't need to have the gang enhancement to be able to find Melly guilty of first-degree murder. Okay, but this is, just to clarify, this is what the law says. The law, this is taken from the Florida statute, that if the jury has recommended a sentence of death, if the jury has recommended a sentence of death, and at least 8 jurors recommend a sentence of death, the court, after considering each aggravating factor found by the jury, in all mitigating circumstances, may impose a sentence of life in prison without the possibility of parole or a sentence of death. Meaning, even if the jury, let's say 8 of the jurors, agree altogether that the accused should get the death penalty, the judge can still not agree with them. The judge can still say, I'm only going to impose a sentence, a life sentence, without the possibility of parole. The judge does have that, has that power. And then listen to this. The court may consider only an aggravating factor that was unanimously found to exist by the jury. The court may impose a sentence of death only if the jury unanimously finds at least one aggravating factor beyond a reasonable doubt. So this idea that the burden of proof for the gang enhancement is beyond a reasonable doubt is true. The defense is right that the burden of proof for the aggravating factor of the gang enhancement is a reasonable doubt. That they're right about. The defense is right about. What they made a mistake about is that you don't need that in order to find that Melly should be convicted of murder in the first degree. That's a separate issue. So he can be found beyond a reasonable doubt to have committed murder in the first degree. And then the second question about whether this aggravating factor of the gang enhancement, of the gang association is present, if that is also found beyond a reasonable doubt now, and the jury unanimously found that, now the court can consider a death penalty. So that was the mistake the defense made, in my opinion, and they just misstated the law, and that's where this whole confusion came up. So, like we always say, there's never a dull moment in the Melly case. Jury selection is still going on, and that's it for now. We'll keep you posted as the trial continues to get closer and closer. See you next time.